Welcome everyone to the Responsible Bytes podcast, the podcast where we talk about all things safe and responsible technology. I'm your host, Dr. Zena Assaad, and today we are joined by Dr. Damian Copeland, who is the director at Article 36 Legal. Welcome to the podcast, Damian.
Hi, Zena. Thank you very much for having me.
Oh, I'm so happy to have you on the podcast today. Damian, can you explain for everyone what Article 36 Legal is and what you do there?
Absolutely. So Article 36 is a legal firm. We're an Australian-based firm specialising in the legal review of new military weapons technology. So our core focus is providing advice to defence industry, to governments, to non-government organisations, even to investors or venture capitalists investing in industry on the legal requirements for new technologies that may enter into the military domain. Our aim is to bridge the gap between technical innovation and legal compliance by ensuring that from the very start of a capability's design and development through to its maturity and introduction into service with the military, that IHL and international law requirements are considered and addressed throughout the process.
So I think a lot of people may not be aware that weapon systems actually have to go through a legal review process. So can you explain that for us a little bit, what that legal review process is involved for weapon systems?
Absolutely. So all countries are required by international law to determine the legality of weapons before they use them in armed conflict. That the source of that obligation for countries who are party to the first additional protocol to the Geneva Conventions of 1949 are obligated by a specific rule in Article 36 that requires the determination of legality. And so what that does is place a clear obligation for states to establish a national process by which they consider and determine legality. Now, in practice, this obligation is normally undertaken during an acquisition process. So many countries have formal capability acquisition processes, and part of that will be to seek a legal review that will inform the decisions as to whether to acquire a particular weapon system. So in Australia, Article 36 reviews are done throughout the acquisition process and take the form of a legal advice to the Commonwealth, which gives advice as to whether a weapon is lawful or whether it should have limitations placed on its use to mitigate legal risk.
Can you give me one example of what would make a weapon unlawful?
So there are a number of things that are considered in a legal review. They include specific international law prohibitions and restrictions. So probably the most commonly known ones are the conventions against anti-personnel mines, conventions against cluster munitions. So if a weapon uses those types of technologies, they would be specifically prohibited for states that are party to those particular treaties. There's also a number of general international law prohibitions that apply to all weapons, and in particular, they are weapons that are indiscriminate by nature. That means that they can't be aimed at a specific military objective, and so are just as likely to hit a civilian object as they are a military target. All weapons that cause what's referred to as superfluous injury or unnecessary suffering. So that is harm to combatants, so military personnel, that is beyond what is necessary in order to achieve a legitimate military objective. So a legal review analysis will consider all of those things and in doing so make a determination as to whether the subject of the review offends any of those restrictions or prohibitions.
So then with the introduction of autonomy and AI into weapon systems, how does that complicate or make the legal review process a little bit more challenging?
I think autonomy and AI in weapons, firstly, is not new, and depending on how you define autonomy, they argue have been around for quite some time. But where we start to talk about less deterministic, more artificial intelligence-enabled systems, where there are issues around predictability. If the system is designed to perform functions that engage international rules, so for example, international humanitarian law provides rules that govern means and methods of warfare, so rules around distinction, as in distinguishing between lawful and unlawful targets, rules regarding proportionality, which is an assessment of expected collateral damage against civilian harm. So if an AI enabled weapon system performs a function that engages any of those specific rules, then arguably a legal review needs to be able to determine whether it's capable of performing those functions in a way that complies with the state's legal obligations. There are a range of unique characteristics that AI also presents: predictability, potential issues around gaps in lawful accountability. It's well recognised that the weapon system itself is not a legal entity, not subject to the laws with assigning responsibility. Only humans, and in the case of IHL, military commanders and states are responsible in international law. So there's issues around risks in gaps in responsibility. So all of those things present challenges. And of course, a weapon system is not used in a static environment. Battlefields are complex, unpredictable, and so issues around how an AI-enabled system will actually function in a complex environment without risking some of the issues that are well recognised in that with artificial intelligence in unpredictable environments.
So I want to touch on something that you mentioned there, and you spoke about the risks in gaps in responsibility, and you also spoke about how with conventional weapon systems, a human is always responsible. The weapon system itself can never be held responsible. It's an inanimate object. And I would imagine it is the same for autonomy in AI. So where does this risk in a gap in responsibility come from?
So the risk is around who the law holds accountable in the event that there is a breach of the law. So if we use the example of a soldier firing a rifle, then the soldier is the one who is undertaking the analysis that is relevant to liability. So the soldier will distinguish between what is lawful and unlawful. So if a soldier fires his rifle or her rifle in armed conflict at a civilian, then that is unlawful, and the soldier is quite clearly held responsible. If, however, a weapon system is enabled by AI such that it's able to perform that distinction role, and so effectively the weapon operator releases the weapon, if you like, and then the weapon system itself selects the target, then if the weapon system selects an unlawful target, then the question is, how does that operator be held responsible? So a legal review would be concerned with making sure there are clear lines of responsibility such that in the event that a weapon system performs in a way that is unexpected, then there needs to be the ability to find the responsible person or entity, including the state, who is accountable for that particular breach of the law.
So you're talking about embedding responsibility in the weapon system prior to it being deployed, is that right?
So, talking about mitigating risks where there is a potential question around responsibility. So, if the use of a weapon in a particular environment, let's say a particular environmental or operational circumstance, means that there's a higher risk, for example, of a false positive in a target
Hmm.
recognition or an error. Or because of the brittleness in the system, then a legal review would be interested in restricting the use of the weapon system in those circumstances, such to reduce risks around errors, such that there would be questions as to responsibility.
Okay, so then I want to unpack this a little bit more, and I specifically want to unpack the legal challenges that differ between a conventional weapon system and a weapon system that has autonomy or AI-enabled capabilities in it. So can you draw out for me a little more what some of those legal challenges would be?
So, autonomy in weapons and certainly artificial intelligence in weapons raises a number of unique challenges. So I mentioned already the risks around unpredictability.
Hmm.
And so from a military perspective, whilst the law doesn't require predictability expressly, it is implicit that the operator of the weapon can understand and expect what the weapon's going to do. That's important for planning and deciding when it's appropriate to use the weapon in a particular circumstance. But if an AI system renders a weapon unpredictable, then that is an issue both from a practical perspective. A commander would be reluctant to use an unpredictable weapon system, but also from a legal perspective because it clearly elevates the risk that the weapon will perform in a way that is inconsistent with the, the rules of international humanitarian law. There are also concerns for the ability to understand how and why a weapon system has operated in the way it did. So, in the event that there is a malfunction or an issue with its performance, then there's a clear need for the military to be able to understand why. It's well known that artificial intelligence, in particular neural networks, are challenging in terms of their transparency. There's what's called the black box, such that it's difficult to understand the internal processes that cause the output. So there are a number of unique issues with autonomous weapon systems that will need to be considered. And in this way, we certainly argue at Article 36 Legal the need for IHL compliance to be considered from the very beginning of the design, such that these risks can be identified in the development and mitigated, rather than being considered at a later stage of maturity where it may be more difficult to mitigate the risks.
So trying to be anticipatory instead of trying to retrofit the system afterwards.
That's exactly right. So we say that the law needs to be built in to the
Hmm.
system, not bolted on at a later point of its development.
I love that description. So I want to bring in the humans a little bit here. We've been talking about these systems, but really these systems don't operate in absence of humans, especially in a military context. And one of the things I find quite interesting is that not just in the military context, but in civil context as well, people often use technologies in ways they weren't intended to be used. And so we're talking about trying to put these legal barriers around these technologies. But how do you put legal barriers around the way people are able to use them, especially in an environment like a military context where it is quite dynamic, it is very high risk. There are things happening, in kind of split second decisions. So how do you put in legal barriers around the way people use these technologies in those contexts?
So I guess the military is like, I guess, most large organisations. They, in order to uh, ensure that they operate in an effective, in a lawful, in an ethical way, that they have layers of governance, if you like, around weapons, and that contribute to the use of force. So those layers include training for individual members of the military. All members of the Australian Defence Force are trained in the laws of armed conflict, or IHL. Each unique weapon is subject to specific training and qualifications. So military members aren't able to use a weapon unless they are qualified, and that qualification includes understanding the limitations on the weapon. So, for example, where the weapon is most effective and where the weapon should not be used, because there may be risks around the legality of its use. There are also a range of tactics, techniques, and procedures that are applied collectively and individually. So, how a military unit would operate with a particular weapon system. Australia, like most militaries, use rules of engagement, and those rules of engagement are specific to a particular operational environment, and within that, those rules may well place limitations on the use of specific weapon systems, such to avoid any concerns around legal risk.
So then what about people using weapons in ways they were not intended to be used, but that technically are not unlawful, but come with their own complications? So I'm thinking here about drones. When drones first started to be introduced into military context, I think people were quite creative with how they used these weapon systems, and it wasn't necessarily unlawful, but it was potentially concerning because we were seeing weapon systems being used in a way they hadn't been used before.
Yeah, that's right. And I think this is not a new problem
No.
for artificial intelligence. The question, I think, raises a number of issues. Firstly, from a legal perspective, members of the military are trained in the laws of armed conflict, which include principles. So distinction, proportionality, humanity are all principles of IHL. And in the absence of a specific rule dealing with an exact use case or scenario, those principles continue to apply to guide how military members conduct themselves in armed conflict. From a legal review perspective, the legal review contemplates the legality of a weapon based on a normal or expected use. And so if after the introduction into service of a weapon system, a new or novel use is discovered, so for example, as we've seen with drones, then the legal review obligation in Article 36 refers to a new weapon, means, and method of warfare. And so that new might include a new use for an existing weapon system, and so the new use on the battlefield, for example, should be the subject of further legal consideration in terms of a legal review. Now, that might occur locally by legal advisors who are deployed to support the military commanders on the battlefield, which is a requirement under international law. Or it could happen more centrally from the organisation who is normally responsible for legal reviews. So a new use, firstly, would not be outside domains of IHL because the principles of IHL continue to apply, and the new use would need to be the subject of further legal review to the extent that it was different to the use that was contemplated in the original review.
And so what would it look like to capture these kinds of challenges in a legal review process?
So there are a number of ways that these challenges are met. So from the Australian perspective, over the last couple of years, the Australian Defence Force has worked to update their legal review process. That includes a revision of their legal review guide, and the guide now includes a part specifically dealing with autonomy in weapons. That guide's publicly available for the people that are interested.
We'll leave a link for it in the show notes.
Wonderful. But also there's benefit in countries who have the legal review obligation from comparing their processes, their national directives, methodologies on legal reviews. And so, again, for the last couple of years, Australia has led an international expert meetings on legal reviews, focusing on autonomous weapons, which have helped exchange best practice amongst countries on how they go about meeting the challenges of new technologies. So this expert meeting continues on an annual basis and will undoubtedly include other areas of technology, cyber, for example, in the legal review context.
And so, who is it that holds people accountable against this legal review process? So, if someone was to use a weapon system in an unlawful way, who is the governing body that holds these people accountable?
So the law requires the state, and naturally through its agent, the military, to do exactly that. So there are specific rules requiring the investigation and reporting of breaches of IHL, and so the national mechanisms through domestic law. So there may be a military disciplinary legal system that would be the mechanism through which an investigation of a breach and then the prosecution and prevention of further breaches occurs. There are also international mechanisms. So the Rome Statute created the International Criminal Court, and that body also has a role to play in breaches of international humanitarian law.
But it's an opt-in system, isn't it, with the International Criminal Court?
So it's a system that operates in a complementary way. So states who are party to the Rome Statute are required to undertake national investigations and to, where appropriate, prosecute breaches of IHL. It's only where it's the state is not properly undertaken the national process does the jurisdiction of the International Criminal Court enliven. And so in that way, the primary responsibility lies with the state, but absent that, where the state is unable or unwilling to deal with breaches by its militaries, then the International Criminal Court can play a role.
So I'm thinking of this from a systems engineering perspective. That is my background, and I have an aviation background. And typically, the governing body who holds another body accountable is separate. It's not within the same organization. So what are the challenges of having that kind of internal structure where it is your own governing, it's all within the one system? So what I'm thinking about here is, because it was two separate bodies, there were separate expectations and separate ways of dealing with things.
Yeah.
So what are the challenges of having that whole legal process embedded within one organization?
Yeah, I guess there are challenges, but that's the nature of domestic law. In most cases, the offences that are the subject of, for example, the Rome Statute, which creates the International Criminal Court. So the offences that are the breaches of international humanitarian law are but through the ratification process brought into domestic law. And so in Australia's context, that means that the prosecution of a criminal act under Division 268 of the Commonwealth Criminal Code actually requires the Attorney General's certificate to prosecute. And so there is a check and balance built into the system because of the serious nature of the criminal offences. And so there are, it's a natural product of domestic system that it is internal to the state. And I think many states have these mechanisms in place, and the extent to which they are undermined by individual organisations, I think, is eliminated. I think because of the uh, the way in which the law is designed. So the military can't dictate what is and it isn't the subject of criminal prosecution. That would be dealt with separately by the Commonwealth Prosecutor and indeed the Attorney General.
So then bringing this back to technology in weapon systems, if these kind of legal processes happen at a domestic level, does that mean that we have different standards and benchmarks across different states for weapon systems?
No. Well, do you mean states as in Victoria, New South Wales, or states as in countries?
States as in countries. Sorry, I should have
Oh,
been
okay,
more
yes.
specific.
Well, yes, that's absolutely right. So, for example, our countries have different legal systems, of course, and Australia's legal system, which is very much a product of the British system, does have, I guess, standards of criminal responsibility which may differ from other states. I think the difference, though, is not such that there would be um, a clear distinction between how the Rome Statute is applied domestically from one state to another. It's simply how that law is applied in the context of the domestic law. So I think the risks that uh, different countries prosecuting the same offences would come out with vastly different outcomes. It is minimised to that extent, noting, of course, that different systems have different rules of procedure and evidence and such things.
So then from a strategic military perspective, I know there are a lot of arguments from a civil domain of people saying that things like regulation and law inhibit innovation. And I'm not somebody who agrees with that, but that is a prominent argument that's made against regulation. So from a military strategic perspective, what do you say to people who may make the argument that these kind of legal processes for weapon systems are actually inhibiting strategic military advantages?
So those arguments, I think, are not really founded in a thorough understanding of how the law operates.
Mm-hmm.
I think IHL doesn't prevent the use of weapon systems in armed conflict in a way that would inhibit um, the design and development and innovation within technologies. So it's only where the technology includes prohibited or restricted types of weapons and prohibited or restricted uses of weapons. And so it's well understood, certainly from Australia and its allies, that the means and methods of warfare are not unlimited. And so to suggest that the innovation is being inhibited by the law is not quite right, because it's simply a requirement of Australia's domestic and international legal obligations to operate within international law, and in particular international humanitarian law. So the importance of considering legal requirements it is, I think, in my view, increased in the technological innovation space, because the more that the technology operates in a way that engages legal rules, the more those that are designing, developing, programming, training the technology need to understand what those rules are. If that consideration is done at the end of a development process, then there may well be circumstances where that technology is not able to be used to its full capacity, simply because of Australia or other states' legal requirements. But I think engaging early means that the risks of the law inhibiting innovation are vastly reduced. So understanding what the boundaries for that innovation are, and that goes not just for the military, but for aviation, for any other context, autonomous cars, all is important, I think, in the development and design of new military technologies.
So I agree with you that building these kinds of things in throughout the life cycle of the system is the most effective way to do it, because I really liked the description you gave before of building it in instead of bolting it on. And I do agree with you that bolting these things on at the end can actually inhibit innovation. And I think sometimes this is where these arguments come from. So can you tease out a little bit more for me, maybe one example? For example, if we go back to the drones example, what it would look like to have these systems be lawful by design?
So I guess I can use the Lawful by Design initiative that Article 36 Legal is launching as perhaps an example of that. So what the initiative seeks to do is to really to bridge a gap that exists right now between the increasing development of military technology outside of the military domain. So private companies, tech innovators, small to medium enterprises, developing technology that has a military application, but developing it to a point of maturity without having the benefit of understanding what the military requires, and in this case, what Article 36 requires. It's like turning up to an exam not knowing the subject. So I think there's a lot to be said for bridging that gap by industry and others informing themselves of what the military requires by virtue of Article 36, understanding what the legal issues are considered in the legal review, and making sure that they design their systems in a way that are capable of passing a legal review, rather than waiting to the day of the exam and finding out whether or not that they're actually going to pass. So Lawful by Design has two components. It asks industry to voluntarily consider IHL and Article 36 legal requirements in the design and development. And that's possible through a range of ways. There's any number of literature available. Article 36 Legal has produced a Defence Industry Guide to legal reviews. And so there are many ways that they can inform themselves. And then the second component is placing the emphasis on the states through their military acquisition organisations to actually require, in the tender process, industry to demonstrate their ability to comply and pass with a legal review. So it's coming at the problem from two directions, but hopefully what it's going to do is normalise the consideration of IHL rules and requirements very early in the design and development of new military technology.
So these legal review processes, or to have a weapon system that is lawful by design, will require quite a deep understanding of the technology itself. And AI specifically is quite opaque in its nature. So what is the challenge you find there with trying to embed something that is lawful by design with a technology that is deliberately opaque?
So the challenge is finding a methodology that's going to allow, I guess, a reasonable determination of legality. And so with the traditional legal review process, the process makes a number of assumptions that don't apply to autonomous or AI-enabled systems, including command decision systems. So the assumption is that they will essentially be used in a lawful way. And that relies on the responsibility that attaches to the human operator, which doesn't apply where the technology actually performs some of these functions which are regulated or governed by legal rules. And so what we've been working on, and what Article 36 legal advocates is what's referred to as the functional approach to legal reviews. And so that functional approach effectively adds an extra process of consideration onto the traditional legal review process and tries to identify how and where and in what circumstances issues around opacity, around predictability, around reliability, explainability, these issues that are unique to artificial intelligence and AI enabled systems can be tested and analysed such that the state can confidently assess whether the system can perform in a way that complies with its legal obligations. Now, legal review processes are admittedly more of an art than a science. And so this functional approach very much would rely on multidisciplinary advice from experts from a range of fields, computer sciences, engineers such as yourself, and other technologists, ethicists, to understand the risks in the performance of specific functions.
And how do you find that dynamic? So I do work in an interdisciplinary field, and one of the challenging parts is trying to speak the same language because we all have our own language that we speak within our disciplines, and sometimes those languages really don't come together very well. So what do you think is one of those key challenges that comes with requiring that interdisciplinary approach to lawful by design?
I think you're right. Finding a common language can be challenging. One of the things that I find, though, is that the law is in many ways broadly applicable to a range of circumstances, technologies. Certainly, IHL is written to be agnostic to technology, and so applying IHL to particular capabilities or use cases can often be done in a way that is understood across multidisciplinary areas. And so it can be challenging, but not difficult. And certainly, in many cases, the difficulty is in the lawyer understanding the technology as opposed to the technical expert understanding the law.
Do you find, though, that from that perspective with the technical expert, one of the things because I do a lot of stuff in the regulation and standard space, and one of the challenges I find is understanding the why for technologists. You ask a technologist a particular question about, it needs to be, it needs to abide by this law, or it needs to meet this standard or this regulation, and that it's often contested, but why? But why? Because we're seeing things from different lenses. So do you find that comes up at all?
Yes, but as I mentioned earlier, there are some very clear and I think very useful principles that apply to IHL. And so I think those principles can help provide the sort of the base understanding of a specific rule, because a rule will generally be an application or of a particular principle. And so in many ways, taking issues down to the basic principle level can help to provide a sort of an understanding of where the law is coming from in requiring or restricting a particular process.
Okay, so then can you tell me a little bit more about the Lawful by Design initiative that Article 36 is doing, specifically when it is going to be released and how people can engage with it?
Absolutely. So we are launching the Lawful by Design initiative on the 12th of June, so it's just over 2 weeks away. It's an online event being hosted via a Zoom link. So the details of the launch event are available either on the article36legal.com website or via the Humantix site. Both are can be easily found via Google. The event is being held at 5 p.m. Australian Eastern Standard Time. That's to allow European guests to attend, so a 9 o'clock start for those. We have a number of speakers from different relevant areas. So we have Mr. Laurent Giselle, who is the head of the arms control unit within the International Committee of the Red Cross. And so he will speak to the importance of compliance in new technology weapons from a ICRC perspective. We have Dr. Tristan Perez, who leads autonomy within Boeing. And so he will provide an industry perspective on the value in integrating IHL and Article 36 into the design and development. We have two defence representatives, Wing Commander Kate Conroy, who leads their AI within their Jericho program, and so is involved in a number of AI initiatives within the Air Force. And Lieutenant Colonel Adam Hepworth, who, as you know, is the director of RICO, and he will provide the Army perspective on the importance of Article 36 legal, which he's very familiar with. So it should be quite an interesting event. We've had some reasonable reactions already to it, and we're very much encouraging members of industry who are involved in the design and development of new technologies for defence to attend. We welcome those who are considering or do invest in defence technologies, venture capitalists, for example. But we also look for members of defence and members of non-government organisations, and of course academics interested in the area, who are interested in how this lawful by design process can work.
So I will make sure to leave links for all of this in the show notes for our guests in case they do want to join. And just to clarify, it is free to attend, isn't it?
That's right. It's free to attend. So just register on the Humanities website, and then we look forward to seeing you there. The event is being run by Susan Blaine Consulting, and she is doing a great job putting together in the background the event on the night.
It's a tremendous amount of effort that goes into an event like this. And you do have a stellar lineup. So I know it's going to be really fantastic.
Yeah, I hope so. We hope it's just the start of the conversation. It's introducing the initiative, and we'll be working hard to continue to encourage the initiative in the future.
That's perfect. I think this is a great segue into our last question, which is the question that I ask every one of my guests. And it is, what is one piece of advice that you would give to people for engaging with technology responsibly? So what is your one responsible byte?
Start considering IHL and Article 36 legal requirements from the very start. Don't leave it to the end. If you're developing a system that performs any functions that are in any way governed by the rules of IHL, or may be subject to an international law prohibition or restriction, then find out about it early so that you can integrate that into your design and development, and so that there's no surprises at the point at which you're tendering for a defence contract.
I think that's a great place to end off on. Damian, you've been absolutely fantastic. Thank you so much for being on the podcast today.
Thank you very much for the invitation. I've really enjoyed it, Zena. Thank you.
So have I. And I will leave, as I said, all the relevant links in the show notes. So I will leave links to where you can find Damian, but I will also leave links to where you can find more information on Article 36 legal and the event that is happening on June 12th. So thank you again, Damian.
Thanks, Anna.